welcome back. You're watching the India development debate. Now, Maggi is back in the news, but for all the wrong reasons. The country's top court today has revived the central government's case against Nestle, the maker of Maggi, seeking 640 crore rupees for false labelling and misleading consumers. Why should we be eating Maggi with lead in it? Was the question raised by Justice Chandrachud, who admitted the petition more than 3 years after the court stalled proceedings against the Swiss confectionery giant. Now, the top court has said that the report of the Food Technological Research Institute should be the basis of the proceedings in the case, and the court is not the right forum to vet the content. Strangely enough, the Mysuru-based Food Research Institute, which tested Maggi samples way back in 2015, had come to the conclusion that lead content in Maggi was within permissible levels. Nestle has welcomed the Supreme Court's decision, although it claims that it is yet to see the finer details of the directive. The new twist in the Maggi saga is what we're putting the spotlight on this evening on the India development debate. But before we introduce our panel for the evening, let's listen in to Nestle lawyer Rajesh Batra on what his company's stance is.
The National Commission ordered the second round of testing to another lab. So we went to Supreme Court only against those two orders which are concerned with retesting of samples. Supreme Court today has only allowed us our prayer to the extent that both the orders have been set aside. And the reports received from CFTRI Mysuru have been asked to be relied upon by the National Commission for further trial of the case. Look, there are certain issues which are triable, which were never challenged before the Honorable Supreme Court. So those issues legally will have to continue before the National Commission because we had never challenged those issues or taken those issues to the Supreme Court. Whether lead was within the permissible limits or not, the issue has been settled by the reports of CFTRI, which says that the lead was within the permissible limit, and that issue has been closed now.
And for that, let me introduce our panel for the evening. We've got Gurcharan Das. He's an author, commentator and former CEO of P&G India. We've got Harish Bijur, CEO of Harish Bijur Consultants. Bijon Misra, who's an international consumer policy expert, and senior advocate Vikram Nankani is here with us as well. Gentlemen, good evening and thank you so much for taking the time out. Mr. Nankani, let me begin by asking you, what has made the Supreme Court revive the case against Nestle today when in December of 2015 the court stayed criminal proceedings against the MNC food giants? Really help us understand what's changed between now and then.
So the 2015 order was an interim order which was passed by the Supreme Court. And today, when the matter came up for further hearing or final hearing of that case, all that the Supreme Court said is that you have material in your possession. Please go and show it to the correct forum. And that is, in a way, exhausting the remedy which is already available. So the Supreme Court has really sent the matter back for final hearing or final disposal, as we call it, to the consumer forum, which will now conduct the trial. And both sides can marshal evidence which they have, and they will evaluate this evidence and then come to a final conclusion whether Nestle has a defendable case or not. So really speaking, it was only an interim order which in 2015 was subject to further hearing, and what the company today seems to have argued, we don't have the copy of the Supreme Court order, so we are only going by what apparently transpired in the court, and it seems that the company sought to argue that once the report had come in from the labs, the case was a non-starter of a case and matter would stands concluded in favor of the company. The court only felt that this is something which is proper for the forum to decide, and when they are the final fact-finding authorities. So the consumer forum will appreciate the evidence and then give its final verdict. So that, I think, is the limited scope of the Supreme Court order today.
So much for setting the context, really. Bijon Misra, let me ask you, what do you make of the centre's contention that Maggi is indulging in unfair trade practices, false labelling and misleading as advertisements, and that it should be penalized for misleading consumers?
You see, there has been charges made against Maggi based on which the government of India, for the first time in 30 years, decided to go before the NCDRC on behalf of the citizens to claim compensation of 640 crores. So this is for the first time the government of India has taken a position that they should also intervene or take petitions before the court on behalf of the citizens rather than letting the consumers go and fight it out in the courtrooms. So this has been a good kind of a position for us as consumer groups and for the country, that as per the law the government has been empowered to go before the court to claim compensation on behalf of the consumers. But then the Supreme Court had given a stay order on this proceeding in NCDRC, in 2015 when this case was admitted in NCDRC. But today what has got established is an excellent kind of a point made by the bench, saying that please go back to the court where it needs to be looked into. And they also commented, when they tried to talk about the counsel of Nestle tried to convince the bench that it was within permissible limits, the bench said that what is permissible we don't understand, but we do understand that why should the consumers consume lead. So there is now a kind of a question asked or questions raised by the Supreme Court, which of course we have to see in the order what they write at the end of the day. But NCDRC will definitely have to understand in terms of standard settings, because in our country, the standards are now quite outdated and it needs to be revised, revisited and well understood. So there is a role of the regulator like FSSAI, Food Safety Authority, to ensure that all food products which are sold in the supply chain in our country adheres to certain standards which are not detrimental to health, protects the consumers from any kind of a contamination which tomorrow would lead to maybe an avoidable disease. So we need to understand how the NCDRC will look into this compensation claim which has been made on misleading advertisement, on unfair trade practice. There are a number of allegations which have been put before the NCDRC, and how legally it will stand, we have to understand that. And we as consumer groups and people who look into consumer policies will definitely look at it very closely and watch the proceedings. And if need be, we will also intervene before NCDRC if need be, to understand that the robust mechanism of food safety is inbuilt in our system. And we have to ensure that the Food Safety Authority not only sets standards, but also protects the consumers from unsafe food.
Sure.
So we want to see India emerging as a country which would implement effective laws.
Okay, Gurucharan Das, let me ask you, Maggi is an international product from a reputed global firm. It's sold across continents, including countries that are known for their food safety standards. What makes India different then?
Well, this is what is so bizarre about this. When your channel, ET Now, called me, they said that the case is being revived. I thought Nestle was going to sue the government of India for the losses it incurred wrongly by banning the product at that time. And I have known Nestle. I've competed against Nestle in 3 countries, and I just know that companies like Nestle, Procter & Gamble, they have too much to lose. They are worldwide companies, and their own standards are much higher than the standards of the countries in which they operate. This is country after country. I've seen this. So I find this very, very bizarre, and I find that this is a kind of a cheap target almost, where we should be concerned. The consumer protection group should be concerned with the quality of water that we have, the quality of air that we breathe, which is much, much inferior to what it should be. And so I think this is a kind of, you've got a sitting duck over there, which is a big company, so go after it. it just sounds to me, and I think that's why they're going to lose when they go to court. They may try it because there were so many tests done at that time. You know, massive number of tests, all of them were in favor of Nestle except for a few. And there and so it was when the Mysore laboratory also came up with these findings. I thought this was the natural thing. So I am actually, frankly, very, very surprised, and I just think opening this up is, I mean, there's certainly the court had, if it was an interim order, you know, the procedures, etc., whatever they are, but I think that yes, we should, we want the highest standards of safety.
Sure.
But look at the food that's being sold on the bazaars.
Oh yeah,
Look,
absolutely. Yeah.
that's what the people are eating every day. The
Right.
water we are drinking every day. That's what matters. And you're taking you're just because you have a cheap shot to make against a large company, and you get headlines, you know, you do something like this. I
Right,
wish
Mr. Das,
they
we'll
would
talk
show
about that.
the
Let me
same
just get a word in from
for
Harish
food
Bajur as
safety.
well. Harish Bajur, you know, for Nestle, it's a case of once bitten, twice shy, as Gurcharan Das is saying. It's almost like the MNCs become the whipping boy. How are you looking at it? Is Nestle here a bit of a soft target, and what's the reputational damage that's likely here?
All of us know that Nestle has been through an Amrit Manthan of kinds. It has had a tremendous loss of face, loss of brand, and loss of value. And I don't think it has recovered to date, despite every effort. And to an extent, it looks like the testing process which had gone in was not correct, and the brand was dragged into media, and the brand was actually riled. And I think after having been through that, this reopening is a different kind of a reopening. If you really look at it, I think, we need to appreciate that the Honorable Court has said that, the CFTRI report is the basic report, the foundation report. And I think that's where data rests. And I think the CFTRI had given a clean chit to Nestle, and I think it had moved on. Coming to reputation, I think we should be very careful when we harm the reputation of a brand, because brands are built with great degree of care. And I'm totally in sync with what Mr. Gurcharan Das is saying in terms of saying that a corporate enterprise of the reputation of a Nestle or a Procter & Gamble or an HUL is very, very careful, because at the end of the day, the end consumer is the most important entity for the company. Why would a company go and do something totally wrong consciously, willfully? And I think that is a question we need to ask. I do believe this is going to be not such a big issue, at least not an big issue as it was the last time round. And I think Nestle is going to come out trumps out of the situation. Key issue, key point, we need to look at other foods. We need to look at other beverages. We need to look at food and beverages that cater to the middle and bottom of the pyramid. We must first take care of the health of that segment, and that's very important.
Right. Vikram Nankani, from Nestle's point of view, what legal recourse can the company, take, if any at all? You had a press statement being put out by Nestle saying that we welcome the Supreme Court's, decision, but that's pretty much it. Do you think it's, in a position where maybe it can cry foul, saying that, hey, why are you targeting us? Why are you cherry picking?
Yeah, so before I directly answer the question, let me flag 3 or 4 points.
Sure.
One is that any observations made by a judge in the course of hearing in court cannot be considered as part of the record of the court. So if the judge has asked certain questions, he has raised certain points, he has made some observations, they do not form part of the record of the court. So we cannot get influenced one way or the other by those observations. Number 2, what the court was deciding was only the appropriateness of the forum as the Supreme Court, because please bear in mind that the Supreme Court was exercising jurisdiction under its extraordinary powers of Article 136, which is kind of a summary proceedings where they only go on affidavits and they don't really conduct a trial. So there is really no damage done in terms of Nestle's reputation or anything. The powder is dry. Both sides are free to lead evidence, to decide or debate on all the issues, including the issue of maintainability of such a complaint by the Government of India, which is in the garb of a class action, whether such a proceeding is maintainable, whether the Government of India can challenge and claim damages on behalf of the consumers as a whole, as a class. All these are issues, both legal and factual, will be decided by the National Consumer Forum Commission. And Supreme Court has not foreclosed any kind of a defense from Nestle's side, or has preempted any kind of argument before the National Consumer Commission. So Nestle will be at liberty to raise all questions, all whether legal, factual, whether the standards were met with or not met with. Of course, they will obviously lead evidence to say that they had met with. They will show their international compliances, they will show Indian compliances. As to whether the standards fall short or do not fall short, that I think is the debate which will not be before this consumer forum, because that is something which the regulator under a different enactment, the Food Safety Standards Authority, will decide. Currently the consumer forum will only decide that given these standards, is there compliance by Nestle or not.
Okay.
And in that process, Nestle will also put forth its international practice.
Okay, Bijor Misra, let me ask you and actually put forth what both Gurcharan Das and Harish Bijur have said. If Maggi is unsafe, then you can argue about the safety of food products in our country, from the unorganized players to the cow gullies. You could say, why one rule for Maggi and a different one for the rest? Is it not time that the government finalized a uniform set of norms for all food products?
Yeah, it is time. You see, now, I would like to respond saying that nobody is cherry picking, or there is any kind of a motive behind this kind of a litigation which has come to the NCDRC. Government of India, to its wisdom, understood the need for going on behalf of the consumers when there are reports of safety, when there are reports of undermining the standards. And what we want to see is the process which sets into practice. So we want to see what NCDRC says in terms of this compensation claim by the Government of India, Department of Consumer Affairs. It is not a motivated action. Please try to understand. It is an action where we want to establish the law in letter and spirit. And if Maggi is kind of not guilty, then it should be proved by the court that they are not guilty. The court should come out with a judgment. So why are we trying to make a kind of a observation even before the NCDRC gives an order? Now, in today's context, Supreme Court has very clearly said, please go back where it should be. And the stay which was given by the Supreme Court, they have vacated that. So that is what we expected the Supreme Court to do, and they have done. And what we want to see now is that how the truth will prevail. It is nothing to do with anybody's brand, or it is nothing to do with bashing up some particular brand in our country. We all have to understand that everybody has to follow the law. And if you are talking about, certain people not following the law and certain people following the law, let the regulator decide on that. Who are we to decide on that?
Okay.
And it's not fair on our part.
Okay.
To equate a big brand which makes a lot of profit with some unorganized sector, and you are trying to equate them with that. That is not fair. So let us understand what emerges out of NCDRC. So what's the hurry?
Sure. Gurcharan Das, please do respond to that. I mean, is banning Maggi or finding Nestle the way forward here, or actually having a foolproof check and mechanism to ensure that quality in food products really the need of the hour? And I'm asking this because this is again a flip-flop of sorts coming at a time when the country is looking to improve its ease of doing business, and here we are creating this environment of, confusion.
Well, exactly. I think that it's, obviously food safety is important, but it is just as important that we make that we the problems of the product, the food products that are eaten on the street, the water that is used. That's where the energy of the country needs to go. That if Maggie is guilty, obviously they should be punished. But this was all, we've gone through all that. And now to claim damages. Why not I mean, you go to any street in the country, in any bazaar, the food that is being served, that's being eaten, that is where the problem lies. And what you're doing, nobody is saying that anybody is above the law, but it's a common sense question that we all know about the food, the water we drink. All these things are really what we should be concerned with. And this is where I just think that we've got our priorities all wrong. And what you have actually is almost a desire to bring, because a company has more money, is a desire for publicity, a desire to bring down somebody who is successful, and it just smacks to me of and I hear all these things. I mean, this was an interim judgment, etc., etc. You want closure, but just to go through already the damage that was done to Nestle's and to Maggie's reputation was so great that I would have thought that Maggi would go and claim damages from the government for having ruined its reputation in India.
Okay. Harish Bajur, my last question to you. Apart from legalities, Nestle has to fight a battle of public, perception as well. As a brand manager, if tomorrow you were to handle the brief for Nestle, how are you going to sort of go about building a PR strategy at a time like this?
Typically, I don't think it's about PR as much as it is about the overall brand proposition that Nestle and Maggi brings to the party. Nestle, if you look at it, is a very deep Indian company. Whenever people tend to use the terminology MNC, I tend to worry for companies with deep heritage like Nestle, because, I would call it an INC. It's literally an Indian national company rather than an MNC. But what would one do? One would really take a look at the key issue. And I think Nestle demands a closure. And I think Nestle must be on the front foot asking for this closure. And at the end of it all, I think Nestle must publish a white paper on this entire crisis so that, regulatory bodies, corporate enterprises, and consumers can really look at it and say that, hey guys, this was the ultimate truth. An ultimate truth which happened, and I think this is the way it rolled out, so that in the future, errors of omission, errors of commission don't occur. The key issue is consumer health needs to be protected, and that must never be compromised, whether it be an MNC or by an INC.
All right, gentlemen, with that, I'm completely timed out on this edition of the India Development Debate. But Gurcharan Das, Harish Bajur, Bijon Misra and Vikram Nankani, thank you so much for taking the time out and joining in on the show this evening. Thanks.